Kentucky Spin. Our four core values: respect, education, dignity, empowerment.
Hello and welcome to Kentucky Spin Caregiver Support Group. Today we are going to be cracking the code of medical independence. A little bit about Kentucky Spin or Kentucky Special Parent Involvement Network. We are the Parent Training and Information Center, which you will hear us refer to as a PTI, funded by the U.S. Department of Education under IDEA since 1988, when Kentucky first received a PTI. Kentucky Spin Parent Center provides training, information, and support for children and youth with all types of disabilities, birth through 26 years old, their parents, families, and professionals. At Kentucky Spin, we do not act as attorneys and we do not represent families or provide legal advice. With that being said, we do empower families to advocate for their children effectively. And we use that peer-to-peer model of support to help families access needed information and resources through our own lived experience. We do need to give a disclosure that this is not a training of trainers event. Kentucky Spin does not authorize other agencies or organizations as well as individuals to use the material. This presentation is for educational use only, and all rights and use are reserved for Kentucky Spin Incorporated. I do want to say we want to give an idea of what it's like to come and join us for our monthly caregiver support group. Today's recording is just for educational purposes only and will not share any personal experiences from anyone across the state or personal information. So today we are going to play a small game of Jeopardy! And we are going to find out some information in regards to electronic health records and medical records and age of consent and age of majority. So I really hope that you enjoy learning this information as we go along. The questions that we have today will tie back to our board here. As you can see on the screen, we'll cover medical consent. We will cover EHR. We will cover consent categories. And then we also have a medical potpourri category. How old does a child need to give medical consent? Consent is given to children when they reach the age of majority, which is 18 years. There are exceptions. We have minors who have bore or fathered a child, a minor who is legally married, and a minor who is legally emancipated. Some complications can be conflicting laws between states and federal government, and differences between state laws and collected data. I'd like to read some more information on this just because we want to make sure that all of the information that we give is coming across clear. So most states deem the age of majority as 18, and Kentucky does as well. 18 is the age that a youth or young person is suddenly given full control of all of their medical and personal decisions, unless they are under guardianship. And they are allowed to give their own consent to all medical procedures, tests, and medications. There are many things that can be done to prepare for this major life transition, and we have a whole series of prep work for it. But today we're going to talk about a trickier component of the law. A youth is afforded some privacy in regards to certain key areas of healthcare. This only impacts a few areas, but they can be seen as big areas, and we will cover that in more detail in a bit. As we continue expanding on this, keep in mind that this area of consent is new and there are complications. Conflicting state and federal laws about privacy and consent is just one of those. In most cases, the state law supersedes, but not always. Another complication is that there is a difference between states. A child living in one state with certain rules, visiting a parent in another state with different set of rules, can have complications arise. For what access does the child have to provide medical consent? The area of health that are affected by statutes are as follows. Any age for the following conditions: emergency treatment and services, pregnancy, reproductive services, drug, alcohol abuse treatment, and STIs. So as we previously talked about, there are some exceptions in regards to minors providing their own consent to certain medical or health-related procedures, tests, or prescriptions. These 4 categories include emergency treatments, pregnancy, reproductive, drug, alcohol, or STI, sexually transmitted infections. Currently in Kentucky, anything that is covered under these specific areas are considered to be the responsibility of any individual. This means that a physician or a medical healthcare provider is legally obligated not to share the information regarding these medical concerns with the parents unless specifically granted permission by the youth. An exception to the pregnancy and reproductive services is in the case of sterilization or abortion. Does a child with a disability have the right to give consent? Disability only negates these conditions if a court has appointed a guardian and has taken away the medical autonomy of a child. Over 18 and guardianship has been established with medical, and over 18 and emergency guardianship has been established with medical. Disability does not take away dignity. In the eyes of the law, individuals with disabilities have the same rights and responsibilities as individuals without disabilities. This means that unless guardian has been appointed to specifically address medical autonomy, then your youth with a disability still has the same rights and freedoms to consent to procedures, tests, prescriptions in the areas of emergency health, sexual health, mental or drug health, and be assured that their privacy will be acknowledged and honored. What is EHR? EHR stands for Electronic Health Records. This is an electronic copy of all medical health records and history and can contain tests, medicine, procedures, health history, demographics, progress notes. Simply put, EHR is the name that we use for the computer-based information system that collects all the information about us and what our doctor or doctors need. It will record personal data and facts like name, address, insurance provider, but it will also keep track of all of our medical data. EHR records access are based on 3 categories in Kentucky consent laws. under the age of 13, age 13 to 17, age 18 and above, not under guardianship. So based on the most current consent laws, the following is true. First, anyone over the age of 18, unless specifically under guardianship, is the sole owner of their EHR records. Parents have no rights or access to any of the medical information on their child, regardless of disability or not. Anyone under the age of 13. At what age do parents lose access to their child's EHR or electronic health records? EHR records access are based on the most current Kentucky consent laws, age 13 to 17 and age 18 and above, not under guardianship. So based on the most current consent laws, the following is true. First, anyone over the age of 18, unless specifically under guardianship, is the sole owner of their EHR records. Parents have no rights or access to any medical information on their child, regardless of the disability or not. But when that child reaches age 13, the parents will lose access to their child's health records, and will have to the youth will have to then sign consent for their parent to access that electronic health records. How can a parent get access to view the child's medical records? Gaining access to your child's EHR is called proxy access. The process will be different depending on your healthcare provider and EHR system. Begin with a conversation with your child. Speak to your medical providers and create a parent proxy access. Individuals may request proxy access to a minor under the age of 14. MyChart account by completing and submitting the proxy access portion of the MyChart consent form. Such access will only be granted to parties with parental rights or legal guardianship over the patient, and only to an extent that the party requesting proxy access has the right to access the patient's medical information. A MyChart account will be activated for both the proxy, so the parent or guardian, and the account holder, the youth. If the proxy's legal relationship with the account holder changes, the proxy must inform the physician office immediately. We reserve the right to revoke proxy access at any time for any reason. Sexual and reproduction health. Sexual and reproductive health consent refers to the following: STI, that's sexually transmitted infection, pregnancy, and does not include abortion or sterilization. What is the extent of mental health access? Mental health services are available without parental consent to any minor aged 16 years and older. General health privacy, including vaccines. Parental consent is needed for vaccines and general health with the following exceptions: mental health, which is 16 years, reproductive health, which does not include abortion and sterilization, and STI, sexually transmitted infection, and HIV. At what age does my child get to be independent in the doctor's office? Medical independence is a personal and family choice. Begin practicing early. Work with medical providers to create a plan and normalize. This question goes back to consent. There are a few things that your child is able to access on their own as early as you would like. Encourage your child to talk about their medical providers and normalize the correct names for body parts and body functions. And before going to see medical providers, talk to your child about why you are going and what you hope to achieve. By starting these conversations early with your child, you'll be creating an understanding that you and your child can openly discuss health concerns, alleviating potential problems in the future. Also, speak with your medical professionals. Medical professionals generally start to work on transitioning youth to independence at a certain age. Talk with the doctors and nurse and maintain a plan together and start small with simple conversations as your child, as their comfort level grows. Begin to leave more of the appointment up to your child. You, your child, and your physician can make the decision when it's best for independent appointments. Finally, I cannot stress enough, if you normalize talking about bodies and medical situations with your child, they will be much more likely to keep you in the loop as they age. How does my child's privacy impact my or their insurance? Regardless of age, if a minor independently seeks health care, there will need to be payment. Insurance notification can compromise privacy. An EOB, or explanation of benefits, can compromise privacy. When minors independently consent to healthcare services, discussing payment arrangements become essential. Providers should inform minors about potential insurance billing issues that could compromise their privacy. HIPAA compliance. Generally, anyone under 18 is considered a minor and cannot legally exercise their rights under HIPAA. Instead, HIPAA considers the minor's parent or guardian to be their personal representative, authorized to exercise the minor's HIPAA rights on their behalf. What do I do if my child is over 18 and there's medical issues or emergencies? Unless an individual is under guardianship, the following options are available. Healthcare power of attorney, POA, with HIPAA authorizations, living will, in case of an emergency card through DocuBank, and emergency protocol. When your child turns 18 and is not under guardianship, then they will have full and private access to all their personal medical care. This includes regular visits, specialty care, surgeries, and medications. This can be worrisome for parents of children with disabilities, as the medical and healthcare decisions we all face can be very different to understand. There are a few steps parents or caregivers can take if their child agrees. First, if a child grants access to their medical care via healthcare, POA with HIPAA authorizations, this is a notarized, legalized document that the child would sign and would be carried by the young adult, or placed in the EHR system that gives the parent or caregiver the authority to receive information, and it sometimes make decisions on behalf of the young adult. This is not to override the young adult's choice, and if disagreements arise, they will be reviewed on a case-by-case basis. Make sure a living will is created. A living will is an advanced healthcare directive. This is a legal document that expresses your child's wishes in the case of medical emergencies. Have a direct conversation with your young adult to determine how they feel about certain medical issues and get them in writing. This will help you know what choices to make on their behalf if there is a situation where the young adult can no longer provide consent. In case of an emergency card through the DocuBank is an example of how technology can help. Your young adult might not always be with you, nor may they be in their typical network, vacations, travels, etc. In these cases, it's appropriate to have legal records, wishes on their cell phone that can be accessed by emergency providers. In Kentucky, if there's life-threatening emergencies, it is assumed that an individual would consent to procedures to stay alive unless otherwise stated in a living will. Family members, parents, siblings, adult children, domestic partners, or spouses would also be included in decision-making process if available. And at this time, we're going to show a short video.
Current Kentucky law allows minors to seek certain types of health care without notifying their parents, namely sexual health care, drug abuse treatment, and mental health counseling. But should parents have complete authority over their child's medical records? That's the question posed to a panel of Kentucky senators. Our Clayton Dalton has more as we start tonight's legislative update.
So I had some constituents that came to me because when their child turned the age of 13, they lost access to their medical records until the 13-year-old physically came into the medical practice and signed a consent granting the parent access to the records.
House Bill 174 ensures that parents have access to their child's medical records until they turn 18. The sponsor says doctors will still have the discretion to withhold records if they suspect abuse or neglect. Senator Karen Berg, a Democrat and a physician, pressed the sponsor about how this bill could play out in difficult scenarios.
If you have a 16 or 17-year-old woman who has been sexually abused by her father and is seeking treatment either for her mental health or physically, what will this bill do to her ability to keep her medical records private from her abuser?
I'm not a lawyer, but my understanding would be, I'm assuming you're saying protect it from the person who was the perpetrator. And I would think that the provider would see that as a risk of abuse or neglect, disclosing those records to the person she's saying committed those crimes. So I believe they're protected.
The provider, the medical provider, is the one that you're going to say tells the family they don't have access to the medical records after we just passed a bill that said they do?
Kentucky Voices for Health, a liberal policy organization, says giving doctors discretion to disclose or withhold medical records from parents is too big of a burden.
This is another attack on our healthcare workforce. We are already facing massive shortages in all kinds of healthcare providers, and this throws our providers into weird legal limbo. And when that happens, providers get chilled. When that happens, providers say, I throw up my hands. I call uncle. I can't figure it out.
Planned Parenthood of Kentucky says they believe House Bill 174 could make minors uncomfortable sharing sensitive information with their doctors.
Kids are uncomfortable to have these conversations. And now, with a bill like this passes, we're going to have to disclose to minors under the age of 18 that all of your medical records, upon request of your parents, mental health, reproductive health, are going to be turned over to your parents. This is going to create a chilling precedent.
But some Republican lawmakers see this as a parental rights issue.
And as a parent, I'm responsible for insurance. I'm responsible for food. I'm responsible for paying for the doggone health care. And then someone tells me I may have a role in the decisions that my child makes? Really? Are you kidding me?
And the idea that just because my child might be doing something wrong, I don't get to know about it. All the more reason I should get to know about it, because then I know and I can direct him in the way that he should go or she should go, because that's how I see fit. And it is not up to anyone to tell me my child, someone can have some influence over my child in their health care without my involvement. This is a non-issue. This is absolutely a yes vote for parental rights.
House Bill 174 passed out of committee along party lines and now heads to the Senate for a full vote. For Kentucky Edition, I'm Clayton Dalton.
Lawmakers on that
Next steps. How can we move forward in partnering with our youth, our children, for those open conversations about autonomy and dignity and them taking control of their medical records and choices? Number one is to talk with your child frequently. Number two, speak with your physician and create an independence plan. Number three, utilize Kentucky Spin healthcare resources. And number four, follow legal statutes, changes, and initiatives.
Thank you. Visit www.kyspin.com.